Let's start legal risk and compliance in domain 6. So domain 6 speaks more about the legal concept of legal aspect of the cloud. What are the risks and compliance related clauses which should be known as a student, as the professional for the exam. So what are the different legal requirements? What are the unique risks for the cloud environment? What are the privacy issues related to the cloud, what including the jurisdictional and geographical variations? What is the audit process in cloud environment? What are the methodologies which are followed, and what should be different regulatory provisions should be adapted from the perspective of a cloud environment? What are the implications of cloud to the enterprise risk management? And the next thing is outsourcing of the contract, which is very important, that how do you design your contract? And the final thing is vendor management, where how do you manage cloud service provider as your vendor? Okay, so let's get going on first part. So please note that cloud from the technology or a concept perspective is a complex thing, because the customer can be in one country and the cloud service provider can be in a different country. So it poses different challenges from a legal and compliance perspective, because it can lead to the conflicting international laws. So if you are based out of India and you are dealing with AWS, which is based out of US, then how do you take care of your hosting from a legal perspective? How strong you can secure yourself from a contractual thing is something which should be covered in detail. So what are the legislative concepts or international laws which should be known? Like if you take example from a data protection perspective, United States does not have a national law for a data protection. All 50 states of US have their own different laws. So if you are dealing with anything in US, you might have to go through various laws of the states where you are dealing. If you are hosting your services on cloud, then you will have to also abide with copyright and privacy laws, intellectual property or patents or trademarks laws, various privacy laws, various criminal laws. So these all concepts should be known when you are a CCSP practitioner, as you have to advise the organization on a right direction. Clear? So in this, one of the major regulation which is important from an examination perspective, from a knowledge perspective, is GDPR. It is Global Data Protection Regulation, which has come as a replacement to the EU Data Protection Directive since 2017 or 2018. And it gives a lot of emphasis on certain clauses, like, when you are collecting data for the customer, anyone who is from the EU countries, the data should be collected lawfully by giving the required transparency to the end customer, that okay, you are going to collect the data. There should be a permission before you collect the data. The purpose of collecting the data should be intimated to the customer. The data should be collected only what is required. That is a data optimization. That means minimal data. What is required for the transaction processing only should be collected. It should be taken care that whatever you collect is accurate from a data quality perspective. Like if we are collecting the mobile numbers should be collected in a right format and as per the accurate numbers. There should not be any junk allowed in the mobile number. It's just an example. Then there should be a defined limit for storing the data, and that should be communicated to the customer. So, and then when you are defining that limit, then that should be secured, and there has to be accountability for that storage of the data. So if you are going to store the data for say 2 years or 3 years, it should be communicated. The data should not be transferred to any third party without intimation to the customer from whom you have collected this data. So GDPR is one of the important regulation which is referred now worldwide. And it is not mandatory to follow GDPR for the non-EU countries unless you are dealing with the EU countries in any professional contract. So if you are storing any EU citizen data, or if you are doing any business with the EU countries, then you have to follow the GDPR regulations to safeguard your organization's interest. Am I clear? GDPR is very important from the exam perspective, and what I have explained is that GDPR covers quite important things from the data collection, data storage, data usage perspective. So you need to collect data lawfully. There should be absolute transparency from a customer perspective that why you are collecting the data and what you are collecting, what is the purpose. You should collect only the minimal data what is required from your business perspective. The data should be accurate. You should define the storage limit from a time perspective, that are you going to store this data say for 1 year, 2 years, then once the data is not required, how you are going to destruct the data, and when you are storing it, what is the security and accountability for the data. Okay, so from that perspective, there are certain frameworks and guidelines which are specifically relevant to cloud computing. Okay, and few of them are the ISO 27017, which explains the security techniques to be used on cloud. Okay, the OECD is quite important from the privacy and security guidelines, national privacy strategies, privacy management programs. Okay, it's very important from the definition perspective. Okay, and many times these frameworks are relevant from each country perspective. Okay, I've given specific exam tips on the slide that it is important to promote a consistent approach from an information privacy perspective. That's why these frameworks have been implemented and adopted by the different countries. So EU data protection directives, this was before the GDPR came into the picture, and now it is taken over by GDPR. Okay, and why these frameworks are important? Because what we always say that accountability of the security is always with CSP from an infra perspective. Okay, but that has to be properly documented in the contract, because the ultimate security responsibility from a data always lies with the customer. You cannot say that my data is stored in AWS, so AWS is responsible. You can pass that risk to a cloud service provider only by having a proper contract in place. Otherwise, you cannot. Because ultimately, if you are a bank or any organization which deals with the customer data, it's ultimately your responsibility to secure that data. So there are different regulations, like you have Asia Pacific Economic Cooperation privacy framework. So that is followed as per the specific region perspective always. So that takes us to a very important topic which we have discussed partially in the last module also, is e-discovery. As we are talking here about cloud, in cloud, the data discovery or any kind of analysis is always online. because you will never get access to the physical environment of any cloud service provider. Okay, so e-discovery is very important from the understanding perspective. It's a new concept. It is added in the syllabus, I think, in 2018 or 2019, and it works on 5 pillars. That is, preserve the evidence. Sorry, first collect the evidence, then preserve the evidence, then process, review, and analyze the evidence. Okay, and there are going to be challenges in e-discovery because ultimately the data from the physical storage perspective is always controlled by the CSP. Okay, so your logs and trails are always owned by the CSP. So e-discovery, you need a proper contracting terms to be defined to make sure that whatever support you need from a CSP is available in case of any incident. Okay, so contract with CSP always should include that in case of any event or any specific incident, customer should have full control of data, and he will get a required support from a cloud service provider. Now, cloud service provider will never allow you to have a free access, or it will never cooperate in a free manner unless it is contracted properly, because when you are asking for a copy of data, the multi-tenancy factor will play a role, because that storage will also have a data related to other customers. So cloud service provider needs to have a proper segmentation, proper policies in place where e-discovery will have an effective role. And there are various tools available on SaaS-based e-discovery where you can just run those tools and you can acquire that data. There are host-based e-discovery where the entire responsibility then lies with the cloud service provider. And in case of any regulatory requirements, you can also take help of a third-party vendors to get the e-discovery done. That is like a outsourcing of your e-discovery. And where e-discovery comes in place, it leads to the cloud forensics, which we have discussed in brief. Cloud forensics is governed by the ISO 27050. It's very important from understanding and the exam perspective. You need to understand that how the chain of custody and chain of evidence is handled in a cloud environment, because here we are talking about mainly the logs or e-data. So it is on a binary level that, okay, if the information is gathered by X, how it went to Y, how it went to Z, and how it is stored. So hash values of that data storage is very important from the understanding perspective. Okay, so when you are having your cloud environment, from a legal perspective, it is very important that how you protect a personal information in cloud. So PII regulations and the respective laws will come into the picture. So it is very important that as a customer, you also have the privacy level agreements with the cloud service provider, which will help you to cover yourself. So you need in this context, you also need to understand that what are the differences between the contractual and regulated PII, which is personally identifiable information. So in contractual PII, it is between the organization and the cloud service provider. Like when you are running your call center in cloud, so that is a contractual PII between a customer and the cloud service provider. But the regulated PII is when it is collected. Say for example, if you are collecting the credit card information, then it comes under a regulated PII. Just an example. And then if you are storing any PII in cloud, then it is very important to understand that how you are going to report a breach. For example, if you are covered by GDPR, okay, it is imperative, it is mandatory by the regulation provisions that you need to report any breach of data within 72 hours of the incident. This is very important. There is a possibility of exam question on this, that if there is any breach, what is the regulation or what is a clause of GDPR says that how soon it should be reported. So in PII, it is mandatory from each regulation perspective that how you should do the reporting. Okay, and that is where you should have the contractual components added in your contract specifically to cover your interest as a customer with a cloud service provider. So contractual component should contain like what is your scope of processing, why you have collected this data, are you using any subcontractors from a cloud service provider perspective, if the data is deleted, okay, what is the policy of data destruction, if you are retaining, then what is the policy of data retention. Okay, all these terms, where is a physical location of data, if your data is lost, how is the restoration going to happen, what are the proper security controls, what are going to get implemented. All these contractual components should be added in the contract with the cloud service provider. A contract with specific legislation should cover all the regulatory requirements. So if you are talking about say European Union, then you should follow all the controls what are required from GDPR. So maybe you are required to follow Directive 95 by 46 of European Convention for Human Rights, or you have to follow all the GDPR norms where why you are collecting the data, how much you are storing, are you transferring this data to the third party. All those things contractually should be covered. Okay, then there are specific laws, say in Ireland, there are specific laws in Australia, there are specific laws in Argentina. But as I have highlighted, United States does not have its national level data privacy act. There are certain individual privacy acts in US, they are on a state level. But US does not have any privacy data privacy act on a national level. Okay, so these safe harbor terms, which was specifically having with US and EU, these are now covered specifically under GDPR. So if a data is getting collected from any end customer or any end user, there should be a clear notice that you are going to collect the data from that particular customer. You should always give a choice. That's where you will see that on almost all websites now there is a acceptance taken from the customer that your data is going to be stored. Either you can accept it or you can reject it. Okay, there has to be a clear declaration that if your data is going to be transferred to any third party for further processing, who all will have access to your data, what kind of security will be provided for the data storage, how the integrity of data will be protected, and what kind of enforcement laws will come into the picture. Now, this safe harbor is also extended to few more countries, but it is mainly when the question comes on the safe harbor, it is between US and European Union. Okay, and for this again, it is important that it should be covered under a contract if you are bound by any of these regulations. If say a US organization is dealing in EU or EU is dealing in US organization, then the laws related to HIPAA, GLBA, those all things should be properly handled and taken care of in a contractual terms. As I explained that there are specific laws for data protection in Australia, in New Zealand, and it also mentions that how the data transfer outside Australia or New Zealand should be handled. Like, it is prohibited. So if you are the Australian organization, your data cannot go outside Australia. Okay, or unless they have their contractual terms that if it is going to get transferred outside, what are the privacy considerations or privacy principles that should be followed. And it is very important that if you are having any requirement of data processing by third parties, because ultimately your controller and data controller is the ultimate responsible entity for data processing, even if it is processed by the third party. So that also answers that if you are the data owner and you are storing it in any cloud, or you are using a cloud broker services, the responsibility lies with you as an end customer. Are we clear up to this point? Any specific doubts? Because now we will move to the next point, which is auditing in cloud. Okay, see, when we are talking from a legal compliance perspective, audit plays a very important role. Auditing on premise is way simple than when you are going to do auditing in a cloud environment. Okay, so normally the audits are of two types: internal audits and external audits. When we are talking about from exam perspective, it is divided into three different types: the first party audit, second party audit, and third party audit. So first party audit normally is always an internal audit, which is done by the dedicated department from that organization. Second party audit is normally done by the suppliers, or it is of the supplier. And third party audits are normally the regulatory audits. So there are different regulatory bodies which are required to do the audits, or different regulations which calls for the audit reports to be submitted as per the requirement of law and scope of that particular audit. Okay, so internal audits normally can be audited by the external auditors also. So if you are doing any internal audits, the record can be checked by the external auditors. And internal audits are normally to have a cross check on your security posture. There is very important term here, which is cloud control matrix, which you should understand from an exam perspective. Okay, so when you get into audits, there are various types of audits which are done from a compliance perspective, and one of the very important audit here is of SOC. So normally, when a person is, or when an organization is going through a SOC audit, it helps you to get three major types of report: SOC 1, SOC 2, and SOC 3. Now, SOC 1 also has the type 1 and type 2 reports, and it mainly focuses on financial reporting of that organization. Okay, SOC 2 is very important from information security perspective, because it indicates the five major principles of security, availability, integrity, confidentiality, and privacy of that organization. And it is again of two types: type 1, type 2. Now what are these two? What is the meaning of these two types? For SOC 1 and SOC 2, type 1 report is what is just in time or point in time. So it does not give you any information for say past 6 months or past 3 months. It is at that point of a time what is a posture of an organization If it is SOC 1 from a financial perspective, if it is SOC 2 from an information technology perspective. And the type 2 report is for 6 months to a year period. It gives you the detailed data. Normally, this is a report which, as a cloud customer, you should ask to a cloud service provider. But in 99% cases, the cloud service provider is reluctant to share this data. And for that purpose, normally the third type of report, which is always published on their website, is SOC 3 report. It is for the general users to understand the compliance status of any cloud service provider. Okay, is it clear on the SOC reports? It is highly testable, especially from what is the meaning of type 1, type 2, or what is the meaning of SOC 1, SOC 2, SOC 3. Okay, so when we are discussing on audit, then it is very important that there should be a structure followed for doing the audits in the organization. So there has to be a clear audit scope defined. There has to be an audit scope statement. What are the restrictions or the eliminations from the audit? The gap analysis should be done, and as per that, the audit plan should be prepared. All these things are explained in detail in the Cloud Security Alliance rating on the CSS star. So if you have the Cloud Security Alliance document version 4, you can go in detail and you can understand the scope on audit. Okay, and when the scope is defined, it is very important that you have a proper plan to execute the audit, and in that planning you should make sure that it is clearly defining the audit objectives, it is following the proper defined audit scope, the actual audits are conducted as per the steps defined, and the reports are generated. Okay, so from a privacy perspective, there are certain standards which are defined. So your standard privacy requirements are well defined in ISO 27018, and it also requires you to follow, like, is the consent taken for the personal data, what are the controls on the data, because ultimately as a customer, implicit control. So how the access is provided, how the data can be uploaded or downloaded or destructed, and as per the requirement from the customer. Okay, what are the transparency provisions implemented by the CSP on a location of data? Okay, what is the communication clause or communication process if in case of any breach has happened on the cloud data? Okay, and then as we discussed in previous slide, what are the audit programs or audit plans, and how the reports will be disclosed to the customer on a periodic basis. That is very important from the privacy perspective. And these things are normally defined maybe in SLAs or PLAs. Now, I hope that you understand PLAs is privacy level agreement. It's very important that you understand the difference between SLA and PLA. So when we are discussing about the service level agreements and privacy level agreements, it should clearly indicate from a privacy level agreement that what kind of data privacy will be taken care of by the cloud service provider, and what are the communication channels which will be used to inform the customer in case of any incident. And this will have impact on the organizational policies, where the based on the framework what is followed by the cloud service provider, the organization policies should also have the similar coverage, that what are your policies on financial loss, what are your policies on the data loss, what are your policies to secure the reputational damage. So these all should be covered in the respective policies of a cloud service provider as well as the cloud service customer. Okay, and normally the cloud computing policies which will have impact on your cloud usage are the password policies, your remote access policies, that how you are going to have the multi-factor authentication, and how the CSP admins will have a control, what kind of limitations you will implement, what are the encryption processes you will use, what are the encryption standards you will follow, how the third party access will be given in case you are using say third party tools, like a while ago we discussed about say SIM solution. So how you will provide a third party access, okay, how the incident management will be handled, all those things will be covered under the policies from the cloud service customer and cloud service provider. It is very important that we remember that, and all this is required because risk management in cloud computing is a joint activity. Neither customer nor a cloud service provider can do the risk management individually or independently in cloud, but the full accountability will always remain with customer. I'm repeating this multiple times because there is a definite question in exam that when we are taking the cloud service, but the ultimate responsibility of data security remains with customer. So all these processes, policies, compliances become very important from a cloud customer perspective, that he makes sure that all these processes are aligned and documented in a contract or a service level agreement or a privacy level agreement to safeguard. It is on the risk framework. When we are talking about risk mitigation, it is kind of a risk transferring, like taking a insurance. Okay, let's go to the next point. So this is what I just said, that the risk management in cloud computing is a joint responsibility. Okay. As we in cloud, we are using the distributed IT. So what is distributed IT? Distributed IT is that your IT components are distributed, like you have your on-premise existence, you have your cloud existence, and in cloud also your services are dispersed in a different maybe availability zone. So there has to be certain components which you will have to take care, like how you will take care of your communication, how you will handle your coordination with cloud service provider, how you will do the security reporting. It's very important to document all these things. And that brings us again to the risk management in cloud. So you should do the risk profiling. You should understand that what kind of risks you can accept. So for when we are talking from a cloud service provider perspective, what are the risks from hosting your applications in cloud? What are the risks that you can accept? What are the risks which you can mitigate through having a proper contract with the cloud service provider? What are the risks which you can mitigate through having a proper clause in privacy level agreement? Who are the data owners from a legal perspective? How you will define the data custodian as a cloud service provider to avoid any mishap? What are the standards from an encryption or a storage perspective you will follow? All these things should be properly highlighted and documented as a organizational framework. Okay. So there are now only few points remaining before we get into the question and answer. So I have been discussing multiple times now that we should have a proper service level agreement or the other documents with the cloud service provider. So how you should do the detailing of your service level agreement. It should always contain about how much is uptime guarantee the cloud service provider is giving. What are the penalty clauses in case the cloud service provider is not able to meet the service levels, what is agreed? What are the exclusions on the penalty or on the penalty clauses? How you can get into the suspension of service? What are the data protection requirements? What are the disaster recovery provisions? What are the security recommendations? Please note that this is one of the most important document from a legal compliance perspective to make sure that your risk of data getting stored on a third party environment is mitigated. Okay, so SLA document is of utmost importance to make sure that all your service related factors are covered. In case of any incident, in case of any service level breaches, you are covered with proper penalties. You are having the assurance from a cloud service provider on the disaster recovery. There has to be a mechanism to have a proper information or a communication matrix defined, escalation matrix in case of any request which is raised and not complied by the cloud service provider. And that is where the key SLA elements are, that what is the risk environment we are talking about, is the risk profiling done, risk appetite from the cloud customer perspective. Okay, and this definitely brings us to the final point of this particular module, that how do you handle the risk mitigation frameworks which are followed for the risk management and mitigation. Okay, so risk mitigation is where, you know, either you can accept the risk that okay, I'm aware and I don't have to do any specific action. You can avoid the risk by eliminating the task itself. You can transfer the risk by taking maybe insurance or adding proper clauses. I hope that all these risk mitigation criteria are known. Okay, and for this on a cloud, there are certain frameworks which are followed. So on cloud, it is ISO 37000, and also there is ISO 27005, which is followed from a risk definition and risk management perspective. If the cloud service provider is having existence in European Union, then you also have NISA. Whatever ISO clauses I have specifically mentioned, yes, you need to remember this because these are testable in exam. So ISO 37000 and ISO 27005 are the risk management frameworks, and maybe there is a question on that from an exam perspective. See, whatever laws are covered on this slide, you should read it in detail from the CBK. It is very important, even though it is just a 13% weightage, but this is kind of a simplest module to score the marks. So you should study in detail. That's where I'm repeating one more time that domain 1, domain 5, and domain 6 are kind of your survivors, where if you study it in detail, it's very easy to score. And this section is very important because even as a CCSP professional, you should know what are the legal and compliance related activities you need to follow when you are managing the cloud environment, or you are evaluating a cloud environment, or you are suggesting or you are architecting a cloud environment. Okay, if you are having the practices in US, then the NIST standards also play a vital role. Now, when we are talking about the vendor management, vendor is for you, it can be a cloud service provider or the cloud broker. So you need to understand the risk exposure of the cloud service provider. And for that, again, if you want to understand on the risk management, I will recommend that please refer to the fourth edition of CBK for CISSP. It is explained very well there. If you are already done CISSP, this can be very simple for you. Okay. From a vendor management, it is important that you understand about the common criteria. Common criteria is referred by the ISO 15408, which has the seven assurance levels. So you should know the protection profile, the security target, all those things. And if you are not aware, I will again recommend that go through the CBK for CISSP. It is also important that you know that what are the controls standard defined by the Cloud Security Alliance document version 4.0, which is called CSA star. So it provides a really granular level of details with all controls specifically defined to address the defining categories of the cloud services. So the level one there is self-assessment, level two is attestation by the third party, and level three is ongoing monitoring. Okay. Contract management, I have explained multiple times now in today's session that it is very important that we capture the responsibilities very clearly in contract from a cloud customer and the cloud service provider perspective, which will in turn help the cloud customer and cloud service provider to fix the accountability. Contract management and the service level agreement management are two key factors from a legal and risk compliance perspective, which will be your savior in case of any incident is experienced by the organization. Okay. And the final topic which you should know from this domain perspective is supply chain management, which we have discussed in previous two domains. It is that ISO clause is no more referred. I forgot to change it. It's actually 27,036 now. So this is no more there. It's 27,036. I forgot to remove it. I'm sorry for that. Okay, so this is very important from the supply chain. And always remember that we should have the business continuity and disaster recovery mindset when we are dealing in a cloud environment. So that brings us to the end of this module. It's comparatively a small coverage. From this module, please remember that the compliance from various country-specific regulations is quite essential. So you understand the various laws followed in different countries like Canada, Australia, European Union, APAC. What are the different terms of GDPR? What is the importance of PCI DSS? What are the importances of the risk management framework? What is the importance of the contract and SLA management? Okay, so this brings us to the end of the CCSP Express session. So here comes the first question. The correct answer here is C. This is the standard which specifically defines the SOC reports. Next question. Correct answer here is yes, due diligence. Due diligence is very important in all security domains, so please remember that. Next question. D is the correct answer. These are that way very straightforward and simple questions. Your exam will not have these kind of a simple questions. Let's go to next question. It is again a junior KG level question, and our correct answer is D. Next question. Correct answer here is this is the same thing which we were discussing even from a GDPR perspective. This is the principle which very specifically has got added in many of the recent laws by limiting the collection of data which is required specifically to process the customer request. So all unwanted data collection has been eliminated by these kind of the principles. Okay, let's go to the next question. The correct answer is B. Next question. The correct answer here is A. See, Privacy Shield program is voluntary for non-European entities who want to have the relation with EU. So if you are not doing any transactions or any particular business with EU, then it is voluntary. It becomes mandatory only when you are having any business or any data transfer happening between you and EU, and you do not, yeah, that time it becomes mandatory. Otherwise, it's voluntary. Okay. Next question. The correct answer here is A, because it is dealing with a bank thing, so it's about the SOX. Okay, let's go to next question. The correct answer here is B. Correct. This brings us to the last question. So correct answer here is C. This is the question which even I have got in my exam. So you can imagine that it's very widely covered kind of a syllabus, and you should know, you should go through the documents which I have recommended in the session 1. So this brings us to the question 9. The correct answer is B. It's level 2 when you want to do the third party assessment. Okay. So guys, this is the end of express sessions, and this is how I completed my CCSP through the training. And I had around 2 to 3 hours of study on weekdays for 3 months, and maybe 4 to 6 hours during the weekends. And I practiced around 2000 plus questions before I appeared for exam. And for my benefit, I did my AWS Solution Architect Associate exam before this, which helped me a lot from understanding of cloud environment. And that's how I cleared. That's all from my side, guys.